submission of judgment, item numbers 1 to 4.
In view of the observations made above, we quash and set aside the common order dated 7/9/2020 passed by the learned single judge in the writ petitions. The writ petitions accordingly stands disposed. The writ appeal, Writ petitions are restored to file and shall be listed before the learned single judge. Registry shall accordingly list the case before the learned single judge.
May it please your Lordship.
Yes.
Your Lordship will recall that yesterday I made a mention for one unlisted motion urgent. My Lord, the case is already numbered as 169 of 2023. Perhaps the inadvertence of the registry, it is not listed this morning.
What is the urgency?
Lordship, the urgency is that there is a possibility of the new chairman being elected while the...
Listed tomorrow.
No, Lordship.
Listed
My
tomorrow.
Lord, meeting is to be held today, my Lord.
Listed tomorrow.
My Lord, please, it's my humble request. If there is urgency, Lordship, my Lord will appreciate the law points raised in this case.
If there is a possibility, listed tomorrow. Yes. Next.
May I please, Lordship?
Yes.
I would like to mention, my Lord, item number 42 of the hearing list, my Lord. In the last occasion, I was instructed to obtain necessary instructions and
Yes.
we get the records of the applicants in connection with the interview. So, my Lord,
Yes.
I have recently just received the instructions along with the records. So I will be given some time to produce the records, and then let this matter be listed next week, Monday, Tuesday. Then.
On the prayer of Mr. N. Longkumar, the learned counsel for the respondents, listed after a week. Okay.
Bless you, my Lord.
May I please, Your Lordship?
Yes, please.
I beg to mention item number 29, Your Lordship. Your Lordship, in the last occasion, this Honorable Court has observed that this matter be taken up after the hearing of the appeal, which is pending before the Commissioner of Income Tax, Your Lordship. Until that, there is no hearing, Your Lordship. So
Yes.
if this matter could come up after a few weeks, Your Lordship.
On the prayer of Ms. M.S. Sanso, learned counsel for the petitioner, listed after 2 weeks.
Obliged, Your Lordship.
Yes.
For admission, item number 1.
Yes. Yes, Mr. Limawa.
Counsel is not represented. For the respondent.
Pleadings are over?
Lordship, my senior is on the way, so if this can be taken up after the listed matters.
I hope he knows the court's time. Listed
My
after a week.
apologies, Lordship. Much obliged.
For admission, item number 2.
May it please, Your Lordship.
Yes, please.
Lordship, here I have instruction to withdraw the matter, Your Lordship.
Mr. M. Solo submits that he has instructions to withdraw the petition. Petition is allowed to be withdrawn.
Much obliged.
For admission, item numbers 3, 4, and 5.
May I please, Your Lordship?
Yes, please.
Your Lordship, affidavit has been sent for vetting. However, correction has been sent. So that correction need to be done, Your Lordship. So 1 week may be given to us, so that I will further affidavit, Your Lordship.
Item 3, 4, and 5.
Yes, 3, 4, and 5, Your Lordship.
MS Livika, the learned government advocate, submits that the affidavit of the government has been sent for waiting, and therefore a week's time may be granted to file the same. Prayer is allowed, listed after a week.
Much obliged.
Yes.
For admission, item number 6.
Please, Your Lordship,
Yes.
I'm good at petitioner here. I pray that the matter may become after 1 week, Your Lordship.
Why?
Your Lordship, my senior couldn't be able to attend the court date, Your Lordship.
Mr. Young Gauhati, what is the matter about? Have you filed your affidavit? When did you file?
I'm very sorry, Lordship. They have filed an IA in this case. So in that IA, I have filed my affidavit, but the IA has been disposed of, and in the main petition, I have not filed. I'm sorry, Lordship. Lordship, I will give you 3 weeks time to file my affidavit in the main petition.
Mr. Young Gauhati, the learned CGC seeks for 2 weeks' time to file affidavit in opposition on behalf of
The Union of India, all
the
the
Union of
respondents.
India. Prayer is allowed, listed after 2 weeks.
Lordship.
For admission, item number 7.
May it please, my lord.
Yes.
Lordship, let the matter be listed as in usual course. In the meantime, I'm awaiting the signature of the respondent. He'll be coming on Saturday. So by Monday, I'll file my,
You will file your what?
for affidavit in opposition.
Oh.
Affidavit in opposition to the,
Okay, you file your affidavit in opposition first. MS Judge Jimomi seeks for a week's time to file the affidavit in opposition on behalf of the respondent member,
Private respondent.
private respondent.
on behalf of the private respondent. Prayer is allowed, listed after a week.
Please, Lordship, I beg you. In this matter, Your Lordship has entered appearance as an AG.
Oh.
AG. So I pray that this matter be
Is
listed
it?
before.
Please cancel the order.
Oh,
Please cancel the order. List it before any other bench without me. Okay.
obliged, Lordship.
For admission, item number 8.
Hi, please, Your Lordship.
Yes,
Your
please.
Lordship, on behalf of Inaholi, pleadings are completed, so let the matter be listed for the hearing, in the hearing list.
Okay, madam, okay?
Yes, I have no objection, but
Yes. It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing, listed in the usual course. Okay.
For admission, item number 9.
Please, Your Lordship,
Yes.
I plead this matter may be listed after 3 weeks.
Right. What is the matter?
it's about service, Lordship.
I'm for respondent number 6.
Service what?
The service of the petitioner was terminated, Lordship.
Oh, pleadings are completed?
Yes, Your Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing listed for hearing in the usual course.
Lordship, there is an interim order passed. Let it continue till the disposal of the suit.
The interim order passed earlier shall continue till the next returnable date. Okay.
For admission, item numbers 10 and 11.
May I please, Your Lordship?
Yes.
Your Lordship, pleadings are completed here, so let the matter be listed in the hearing list.
Okay, ma'am.
Yes, Your Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed and therefore the matter can be listed for hearing. Listed in the usual course.
Lordship.
For admission, item number 12.
Yes.
May I please, Lordship? Lordship, the government has already filed their counter. Kindly grant me 2 weeks time to file my reply.
Mr. Sensor, learned counsel for the petitioner, seeks for 2 weeks' time to file affidavit in reply to the counter affidavit filed by the state respondents. Prayer is allowed, listed after 2 weeks.
Deeply advised, ma'am.
For admission, item number 12. Item number 13.
Yes.
My Lord, I've served a copy of the petition to the respondent number 2, who's Army Directorate.
Who is the respondent number 2?
Lordship,
it's
item
for-
number 1 and 2, Your Lordship.
We have for 1 and 2.
Your Lordship, we have filed an affidavit, Your Lordship. The respond, we have served copies to respondent number 4, Your Lordship, in the last issue.
Respondent number 4, have you served?
Yes, 4. I've served the copy.
Who is for 4?
Lordship, sir, Gauhati, he was appearing last time, Your Lordship.
Who?
Sir, Gauhati,
Sir.
Your Lordship, for CGC, Your Lordship.
Mr. Yamawati. You appeared last time.
Your Lordship, I have,
You've forgotten your case.
because this is the director, and I don't know whether I'll be committed to appear for this. I have already sent a notice. Lordship, on the direction of the court, I have appeared. Otherwise, I don't know whether I'll be competent to appear for respondent number 4 or not. Because
You are the CGC.
But this is what directed Indian Army, Lordship, Indian Army veterans. Then my Lordship, can you see the respondent number 4? The Directorate of Indian Army Veterans. So this does not come under the Union of India.
What is your grievance against respondent number 4?
I'm asking for the Army insurance money, which is due.
So the man party is respondent number 4.
Since my father is served in the Army.
From whom are you supposed to get the entitlements?
From the Indian Army. My Lord.
Bye, bye.
And my Lordship, they should have met the Union of India party also. Otherwise, here.
From the army?
Yes, my Lord.
I think your petition at the cause list is not properly drafted, too. Whether you are supposed to get the money from respondent number 4?
Yes, it is.
Veteran. How can this directorate give you the entitlements? What are you seeking? Pension?
Insurance money, my lord.
Insurance money?
Yeah, if it's
And who is supposed to give you that?
It's come under extended army group insurance.
Have you met that authority or party?
Respondent number 4.
If you are confused, check out and come. Listen after 2 weeks.
For admission, item number 14.
Lordship, here I have taken a sufficient time to file the affidavit in opposition.
Yes.
But now I have prepared the affidavit, but I'm waiting for the annexure. So allow me to get a 1 more week time. In fact, I have taken the sufficient time.
How do you prepare affidavit without annexures?
No. I'm waiting for the annexure because.
That's why you said you have prepared your affidavit.
Some documents were not legible, that's why.
What is your case?
Lordship, this pertains to land compensation, Lordship, construction of the 2-lane road, Kohima to bypass road, Lordship.
Bypass.
Yes, Lordship. NH 39, Lordship.
And ma'am, you are appearing for?
Respondent 1 and 2.
Respondent 1 and 2.
It's the union and the NHIDC, Lordship. They have already filed their counter, Lordship.
Okay. So Mr. MT, file your counter. Okay.
Yes.
File your counter. Mr. MT Imsung, the Learned Additional Advocate General, 6 for 2 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 2 weeks.
For admission, item number 15.
May I please, Your Lordship?
Yes.
Your Lordship, on behalf of VZIMO, Board of State Respondents, affidavit is under preparation, so we pray for 3 weeks' time.
My lord, this has been going on for quite some time now.
What is your case, Mr. Joshua?
My lord, the petitioners are DBs, the Bashis, who are being paid the 1993 ROP till date, Lordship, even after multiple ROPs being introduced, Lordship. So we're asking for the latest ROP.
Are you a regular?
No, Lordship.
Yes. This will be the last chance given to the government. Okay?
Yes, Your Lordship.
Mr. Sensor? On behalf of Mr. V. Jamomi, the Learned Government Advocate, 6 for 2 weeks' time
3 weeks' time.
to file affidavit on behalf of the state respondents. Prayer is allowed, listed after 3 weeks. Stop. It is made clear that this will be the last chance given to the government for filing the affidavit in opposition. Listed after 3 weeks.
Bless you, Lordship.
For admission, item number 16.
May I please, Your Lordship?
Yes.
Your Lordship, kindly grant me 2 weeks' time to file an additional affidavit. I need to place on record certain facts, Your Lordship.
Okay, MS AIME, the Learned Government Advocate, 6 for 2 weeks' time to file additional affidavit to place certain relevant records, so certain relevant documents on record. listed after 2 weeks.
For admission, item number 17.
Mr. Lordship. Lordship, I filed my affidavit this morning only.
Okay. Okay.
Lordship, we may be given 2 weeks' time to reply, if so advised.
Okay. Your counsel for the petitioner?
Petitioner, Lordship.
Mr. So-and-so, the learned counsel for the petitioner, he is allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the
All the response.
filed by the respondents, if so advised. Listed after 2 weeks.
For admission, item number 18.
Your Lordship,
Yes,
on behalf of TIBA, for the state respondents, pray for 3 weeks' time.
Mr. So-and-so makes a mention on behalf of Mr. E. Tibapom, the learned government advocate, and seeks adjournment of the case for 3 weeks. Prayer is allowed, listed after 2 weeks.
For admission, item number 19.
Your Lordship, similar for praying for TIBA. For 3
Yes,
weeks'
yes,
time.
same order.
Thank you.
For admission, item number 20.
It's the election
Your
commission.
Lordship, on behalf of SEPOM, kindly let the matter come up after 2 weeks, Your Lordship.
Your Lordship, after I filed my affidavit in reply to the affidavit filed by the Election Commission, State Election Commission, I've been asking time and again to seek instruction.
Who has filed the affidavit? 2 and 4.
Yes, Lordship, 2 and 4.
Chief Electoral Officer and Additional Deputy Commissioner, District Election Officer, Po Boto.
Oh, yes, Lordship.
What is your case about?
Now, my Lord, there is an assurance to give appointment to the landowner in a grade 4 post by the agreement between the landowners and the state respondents, Lordship. Till date in the district election office at Poboto, not even a single appointment has been made, even though the assurance and the agreement has been executed in the 80s, Lordship.
Okay. Who is supposed to give you the appointment? Who is supposed to give you the appointment?
By the election office, Lordship.
By the election office?
Yes, Lordship.
Election office?
The chief electoral officer, Lordship. It's an office
Your
of the
agreement was entered with?
With the government, Lordship, in general, that for the land that we have contributed for free, appointment will be given to the landowners. Now, appreciating the decisions of this Honorable Court, Lordship.
So whether I think it will be proper for the chief electoral officer to give you the appointment? I think it is the government, not the chief electoral officer.
They're all part of the government, Lordship.
No.
We have given our land for free.
The competent authority to give you the appointment is the government, not the chief electoral officer. Anyhow, yes, what is your problem?
Your Lordship, on behalf of SEPOM Chang, let the matter come up after 2 weeks.
You have filed your affidavit?
Yes, state has filed the affidavit.
State has filed?
No, Lordship.
2 and 4 only.
As far as the record is concerned, we have not received the affidavit filed by the state respondents.
Who is representing this Chief Electoral Officer?
MS Santila.
So she is the one who has filed this affidavit.
Yes, Lordship, and after we filed an affidavit in reply to this affidavit, they have been seeking time before the Zombie Court to get some instruction because they have identified the ADC office along with election office as the same office. They are different department, Lordship. So on filing that affidavit, they have been seeking instruction and nothing has come as yet, Lordship.
So your affidavit is for 1 and 2, 1 and 3.
1 and 3.
Should be 1 and 3, Lordship. But it appears my learned friend, Ms. Supongwati, is not present. Ms. Avituli, my learned friend, is only standing for her colleague.
What is wrong with Supong?
Your Lordship, she has some health issues, Your Lordship.
If it will take time, then I think the file has to be given over to some government lawyers. I think Kohima bench has the maximum number of government lawyers. Yes, Mr. Angami, make that arrangement.
Yes, my lord.
Okay.
We'll make the necessary arrangement.
You please note the case number and make an arrangement. If MS Supong Chang
Lordship.
is unable to attend the court because of sickness. Okay?
Lordship.
On the prayer of the learned government advocate, two weeks' time is granted for filing the affidavit in opposition. Stop. It is submitted that MS Sapong Chang, the learned government advocate handling the case, is indisposed. If that be so, it is hoped that the files of the case will be handed over, will be entrusted to one of the available government advocates. Stop. Mr. Nangami, the learned senior government advocate, shall take steps on the matter. Listed after 2 weeks.
Lordship.
Yes.
For admission, item number 21.
Please, Your
ma'am.
Lordship.
Yes, ma'am.
Your Lordship, kindly allow 3 weeks time to file my affidavit in reply.
Okay. The learned counsel for the petitioner seeks for 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Stop. Prayer is allowed. Listed after 3 weeks.
For admission, item number 22.
Your Lordship, here I have similar prayer.
Similar prayer. Okay.
Much obliged.
For admission, item number 23.
Yes,
Yeah,
ma'am.
please, Your Lordship.
Yes, ma'am.
Lordship, I'm informed that there is a similar matter pending before the larger bench, Lordship. So if this matter can be listed after 3 weeks, Lordship.
Yes. Well, which is that case number?
Lordship,
Which is that case number?
read April 35 of 22, Lordship.
Read appeal
35 of 2022, Lordship.
35 of 2022.
22, Lordship.
Is it?
Yes, Your
Is
Lordship.
it? MS Senso, the learned counsel for the petitioner, submits that similar matter is pending in WA 35/2022. Stop. Listed after the disposal of the writ appeal.
Much obliged, Lordship.
For admission, item number 24.
Please, Your Lordship.
Yes, please.
Lordship, I may be allowed 3 weeks time to file my reply and also implementation of the Union of India.
One by one, do it. Which one you want first? Implement or reply?
Reply.
Okay. The Mr. So-and-so, the learned counsel for the petitioner seeks for 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents. To whose
For the
affidavit?
petitioner.
To the affidavit in reply filed by
The affidavit.
the
is
state
also-
respondents.
Yes, Lordship.
Okay, prayer is allowed, listed after 2 weeks.
Obliged, Lordship.
For admission, item number 25.
Please, Your Lordship.
Yes.
I may be allowed 3 weeks time to file my affidavit in reply.
Mr. So-and-so, learned counsel for the petitioner is allowed 3 weeks time to file affidavit in reply.
For admission, item number 26.
May it please, Your Lordship.
Yes.
Lordship, may kindly grant me 2 weeks' time, Your Lordship, to file my counter.
MS Mary, the learned senior government advocate, is allowed 2 weeks time to file affidavit in opposition on behalf of the state respondents.
No charge.
For admission, item number 27.
Yeah, please, Your Lordship. Your
Yes.
Lordship, kindly grant the state 3 weeks' time to file affidavit on behalf of Secretary.
Okay, state respondent is allowed 3 weeks time to file affidavit in opposition. Okay.
For admission, item number 28.
Yes, please.
Hello. In this case, the petitioner, they've been taking 6 months, around 6 months time to file their affidavit in reply. And
you are for the?
I'm for a private respondent.
Okay.
Yeah. And the issue is, the petitioner are in possession of the disputed property, and they're taking up some developmental work and applying for grateful post through the then owner PCs.
What is your case? You forget about the case of the petitioner. What is your case?
Your Lordship, this case is about the inheritance
And?
by adopted son. Now, the petitioner has filed this case on the ground that he can inherit the property.
You are for the petitioner, ma'am?
Yes.
Okay. Okay, then you come here, you come there, let me not get confused. Yes, what is your case?
Yeah, Your Lordship, I'm praying for protection as well as for compliance of the order passed by the Dabashi Court, Your Lordship.
Dabashi Court?
Yes, Your Lordship, for the private respondents, the petitioner is an adopted son, and it is the contention of the private respondents that the petitioner, being the adopted son, he is not entitled to inherit the property.
Okay.
So that is the main contention.
What
Your
was the
Lordship.
order passed by Dabashi?
Your
What
Lordship.
was the order passed by the Dabashi's court? Dabashi's court, the order is in your favor.
Yes, Your Lordship.
So what was the order passed?
Six 2021, Your Lordship.
What was that order?
Saying that all the inherited properties belongs to me, Your Lordship.
Okay. And who are you?
Actually, we are descended from the same family, one father. So the petitioner parents were adopted, but they are claiming that they have paid the debt of our grandfather, and they claim to inherit the property.
Whether this court will be the right forum to adjudicate all these issues?
Actually, our prayer is for this honorable court to direct the village council to take up the matter.
Village council is coming from the Vice's court.
Actually, it is under the jurisdiction of the village. First, it has to be tried at the village court.
The Vices have tried. So I think the right forum will be the civil court. Why are you not interested to contest the case before the civil court? Why village court? Again, going back down.
Your Lordship, the issue was already decided by the Kifri Village Council.
Okay.
However, the private respondents, instead of, if at all they are aggrieved by the decision, they should have approached the appropriate court. But instead of doing that, they have approached the underground court.
Ah.
So, and time and again, they have been violating the orders passed by the honorable courts, Your Lordship, by the customary courts.
That action by itself does not allow you to get any relief from this court.
The scenario is let the petitioner file their affidavit in reply.
You were objecting before.
And take up for the hearing, my lord.
You were objecting before when the question of the extrajudicial authority came in. You are actually like making a submission to allow the petitioner to file affidavit in reply. What is this?
I think, my lord, we have stated, address all the allegations.
What time? What time is required?
2 weeks, because the affidavit is almost ready.
The learned counsel for the petitioner is allowed 3 weeks time to file affidavit in reply to the affidavit in opposition filed by
4, 5, 6, and 7.
the respondent number 4, 5, 6, and 7. Listed after 3 weeks.
Deeply appreciated.
For admission, item number 30.
Your Lordship,
Yes,
on behalf of Tiba, seeking 3 weeks time.
On the prayer of the learned government advocate, 3 weeks time is allowed to file affidavit in opposition.
Yes, Lordship.
To file the affidavit in opposition.
Lordship, there's an interim here.
The interim order passed earlier shall continue till the next returnable date. Okay.
For admission, item numbers 31 to 35.
May I please, my lord?
Yes, Mr. Nangami.
Lordship, in all this matter, I may pray for the respondent number 1, 2, and 3.
Okay.
Lordship, I'm here to receive instruction, Lordship, in all this matter. If 3 weeks' time can kindly be granted to me, my lord.
Mr. Lima.
Lordship, I'm also appealing for the respondent number 4 in item number 31, 33, and
Respondent number 4 in item 31,
31, 33, and 35.
33,
And 35.
and 35. All respondent 4.
Oh, respondent 4. Sure, I follow a similar way.
Yes, yes. Okay.
I have no objection, Lordship, but I pray that this be the last chance, Lordship.
Had Mr. No, not that. Mr. N. Angami, the learned senior government advocate for the state respondents, as well as Mr. Lima Wabang, the learned counsel for the respondent number 3, respondent number 4, in WPC 19/2023, 21/2023, and WPC 23/2023, 6 for 3 weeks' time to file their respective affidavit in opposition. Prayer is allowed, listed after 3 weeks. Okay.
Lordship, there's an interim.
Stop. The interim order passed earlier shall continue till the next returnable date.
Much obliged.
For admission, item number 36.
Your Lordship, on
Yes.
behalf of Vijimo, state respondent seeking 3 weeks time to file the counter.
Okay.
I'm appealing behalf of respondent 1, 8, and 9.
1, 1, 8, and 9. And ma'am,
Lordship, I'm appealing for respondent number 10. Lordship, I'm also yet to file my counter.
you have filed your counter? Filed, no?
My lord, I may allowed to file my affidavit in reply
To?
to the counter affidavit filed by respondent number 1, 8, and 9.
Okay. The learned government advocate, as well as MS Lucino, the learned counsel for the respondent number 10, 6 for 3 weeks' time to file the respective affidavit in opposition. Stop. The Mr. So-and-so, the learned counsel for the petitioner, also 6 for 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 1, 8, and 9. 3 weeks' time is allowed to the learned counsels to file their respective affidavits. Listed up to 3 weeks.
For admission, item number 37.
Your Lordship,
Yes,
can you
ma'am.
grant me 3 weeks time to file affidavit?
MS, okay?
Sir.
Yeah, hear me. The learned government advocate is granted 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Okay.
For admission, item number 38.
Your Lordship, similar prayer here also.
Yes,
3 weeks
similar.
time.
38.
For admission, item number 39.
Your Lordship, here also similar prayer. 3 weeks
Similar prayer. Okay, ma'am. Yes.
time.
For admission, item number 40.
Yes.
Lordship, on behalf of my colleague S. Mere, Lordship, 3 weeks time, we granted the Lordship to file counter affidavit.
Okay. 3 weeks' time is granted to the state respondents to file the affidavit in opposition. Interim order is there?
No.
No interim order? Are you sure?
Yes, Lord. Oblige, my Lord. Yes, Lord.
For orders, item number 41.
Yes, what is this case? Mr. Nangami?
Lordship, actually, I'm not in this matter. We should create is there, but I think this here the state has got nothing much to say, Your Lordship.
You are for the?
Respondent number 1, Your Lordship. Appearing on behalf of my senior Fosico Forte, Your Lordship.
Oh. None appears for the petitioner. Listed after 3 weeks.
Oblige, my Lord.
For hearing, item number 44.
Please, Lordship. If Lordship, may kindly wait for 1 minute, Lordship. Let me go and call Sir P.P. Paul, Lordship.
Yes.
With your Lordship's kind permission,
Yes.
may I pass on the written submissions? I have made out the gist of dates along with the, so that your Lordship may recapitulate on last occasion what I had argued. Quickly, I will just recapitulate that. If your Lordship will see, it is a matter in regard to an order passed by the probate court, whereby a probate order has been issued in favor of the respondent, number 2. on 21/10/2019, the impugned will was executed, said to be executed by Kesari Devi Sethi in favor of Manju Devi Sethi, who is wife of adopted son Amar Chand. And the executant in the will was named as Pradeep Jhanjari. The will was registered on 23/10/2019, and on the very next day, 24/10/2019, the testator Kesari Devi expires at the age of 89. Probate petition came to be filed by the executant bearing probate petition number 1/20 on 7/10/20. The impugned probate is granted on 2/3/2021. Now it is relevant to mention before your lordship that during the pendency of this probate proceedings, different proceedings took place at district Sikar state of Rajasthan between the parties. Those proceedings were in respect to the very same will. The present appellant, by way of filing a suit for cancellation of this will and to declare the will as null and void, a suit was filed. In that suit, my lords, your lordship will kindly see, I am leaving about that patta part, because patta was, I had applied for patta on the basis of my will on 24/8/20. On 28/9/20, Manju Devi files an objection before the municipality. On 7/12/20, Manju Devi gives me a notice treating me to be a tenant in the property. And in that notice, she discloses this will. I replied to that notice on 5/1/21, and on 27/1/21, Annexure 3, page 39 to 41 of the memo of appeal, the interim order was passed in the presence of the Manju Devi, directing that the status quo in regard to the property as well as records be maintained between the parties. Now, your lordship may kindly see this happened during the pendency of the 7/10/2020 to 2/3/2021 proceedings. Nowhere before the civil court it was brought to the notice that these probate proceedings are pending. Now, probate proceedings, my lords, thereafter what had happened, I filed an FIR on coming to know of this will before the district Sikar, police station Sikar. I have mentioned that FIR date is 61/21 dated 29/1/2021. On 2/3/21 also, when the probate proceedings were pending, on the same day the probate order was granted, she files 482 petition before the Honorable High Court of Rajasthan for quashing of the FIR, but do not disclose either of the pendency of the probate proceedings nor even the order of the probate proceedings. Maybe that order might have passed in the evening, but the petition on 2/3/2021 for 482 was filed without disclosing that she has filed any probate proceeding before any court. On 3/1/22, after my lords almost 1 year, 9 months, when the matter came up for consideration on the 482 petition, final arguments were to take place. Just 1 day prior, on 3/1/22, she places the order of probate on record before the Court of High Court, Rajasthan, Jaipur bench. On 4/1/20, after considering all these things, the petition for 482 was rejected, saying that the matter requires investigation on seeing all the documents. Immediately when we came to know on 3/1/2022, we filed the appeal before your lordship on 11/3/2022. This is the list of dates, my lords. Now, I had earlier referred before your lordship that the complete code is there under the Indian Succession Act. There is a complete mandatory procedure which is required to be followed by any party for obtaining a probate. I have mentioned, my lords, the probate hearing which has been granted, there is a gross violation of the provisions of the Indian Succession Act. There is material suppression of facts from the Honorable Court. The suspicious circumstances has not been considered by the court, and in a mechanical manner the probate order has been passed, saying that none of the parties have challenged. opposed. I could not have challenged because I was not known, I was not issued the citation. Though they were knowing that the issue is pending before the civil court. Now, Your Lordship may kindly see, I had referred the provisions of section 276 of the Indian Succession Act on last occasion. It categorically states that if the property of a testator falls in different jurisdictions of different states and district, then asset amount has to be disclosed. What is the cost of that asset falling under the jurisdiction of the very particular district and chapter? Now, if Your Lordship will see the probate petition which I have placed on record as Annexure 2, nowhere they have mentioned the cost of the amount of the asset. They have only mentioned this is the property and this is the property. The cost and asset amount has not been mentioned.
Which provision says that?
276 subclause 3.
Let's see that.
Indian Succession Act 1925.
Which section?
276, my lords, subclause 3. Your Lordship, may I give you Your Lordship permission?
Who is a district delegate? Who is a district delegate?
In which portion, my lords?
276.
B. When the application is to a district delegate,
Yes.
that the deceased at the time of death had a fixed place of award within the jurisdiction of such delegate.
This is not relevant for the present case.
This is not relevant. I am reading subclause 3, where the application is to the district judge, and any portion of the assets likely to come to the petitioner's hands is situated in another state. The petition shall further state the amount of such asset in each state and the district judges within whose jurisdiction such assets are situated. So the necessary provision is that merely referring the asset is not sufficient. A person has to disclose the amount of that asset. What is the cost of that asset? It is not there. Then there there is violation of minors, kindly have parallel to section 279.
Yes.
Kindly have parallel to section 279. Under my written submissions at Roman 2, I have stated
279.
279.
Yes.
That there is a mandatory provision under this section that they have to write and indicate the fact that there is no other probate proceeding pending in any other court. This is a mandatory provision which they have to write in the petition. That to the best of his belief, no application has been made to any other court for the probate of same will. And the word starts with shall state in his petition. Nowhere in the petition which has been placed before your lordship as Annexure 2, there is a mention of this fact. Now kindly have parallel to section 280.
Why are you referring to 279?
279 for the purpose that if a person is applying for a probate, it is mandatory for him to write in this probate petition that to best of his belief, there is no other probate proceedings pending in respect to this will in any other court. The lordship will see that to the best of his belief, no application has been made to any other court for a probate of the same will or for letters of administration of the same estate. He has to declare that. Then, my lords, in Roman 3, I have said that there is a complete violation of section 280. Provides that petition for probate, etc., to be signed and verified. The petition for probate or letter of administration shall in all cases be subscribed by the petitioner and his leader, if any, and shall be verified by the petitioner in the following manner. The manner has also been provided under this Act. The manner is inverted commas, I so and so, the petitioner in the above petition declare that what is stated therein is true and to the best of any information in brief. The verification is in support of affidavit, but verification is there, not there in the support of petition. Like in suits, we write verification and then there is a provision for filing of affidavit. Here, the verification is mandatory. Now, lordship may kindly see next provision, section 281. Verification of petition for probate by one witness to appeal. Where the application is for probate, the petition shall also be verified by at least one of the witnesses to the will when procurable, in the manner or to the effect following namely. And how it has to be verified? Kindly see. I, so and so, one of the witness to the last will and testament of the testator mentioned in the above petition, declare that I was present and saw the said testator affix his signature or mark thereto, or that the said testator acknowledge the writing annexed to the above petition to be his last will and testament in my presence. Now here, both the attesting witness are alive. They have produced their affidavits subsequently during the proceedings. And as I have earlier shown, those affidavits were shown on 3rd of March and order was passed on 2nd of March. But I am showing just now the violation of the act, because when the Lordship is considering, it is the duty of the probate court to see all these things. If these are missing, it is a just cause. Now, specifically the words are, I was present and saw the said testator affix his signature. I will show from the affidavits of the attesting witness also, nowhere they have verified the signature of the testator. Now your Lordship may kindly appreciate section 283. Under section 283, subclause 1, subclause C, there is a mandatory provision that issues citations calling upon all persons claiming to have any interest in the estate of the deceased to come and see the proceedings before the grant of probate or letter of administration. One of mandatory provision is there that if any other person is interested, then a citation should be issued. It was the bounden duty of the applicant as well as the beneficiary who are proceeding the probate proceedings ought to have disclosed before the probate court that the other person is also interested. He may also be called upon to see the proceedings. Rather, they, in a clandestine manner, deprived the petitioner to appear. They did not disclose the pendency of these proceedings and contested the suit in respect to the very same will. I will cite the judgments on this issue that citation is mandatory. Now, looking to all these deficiencies, even if I am not there, if no one is there to object, court ought to not to have granted probate. For that, kindly see section 263 of the Act. Revocation or annulment for just cause. The grant of a probate or letter of administration may be revoked or annulled for just cause. Now the mandatory provision is there that under this provision, I have to show only a just cause. And just cause has been defined. Your Lordship may kindly appreciate. Just cause shall be deemed to exist where the proceeding to obtain the grant were defective in substance. I just have to show my lords and convey to my lords that if the proceedings I show to be defective, it is sufficient to annul the probate. Here I have shown the deficiency on account of 276, 279, 280, 281 and 283. All major 5 portions and sections have not been followed at all. Then the Lordship may kindly see B. The grant was obtained fraudulently by making a false suggestion or by concealing from the court something material to the case. Now, my lords, nothing can be more serious and material to disclose the probate before the probate court that already a stay order of the seeker court is pending. Please take this on record and then decide. As soon as that order would have been placed, I don't think so a prudent court would have allowed the probate proceedings or to grant the probate without issuing a citation to the person who has filed the suit. This is clear-cut suppression of facts from the court. So far as the provisions of,
When the probate was filed before the Dimapur court,
yes, my lord, I have stated in my list of dates.
what was pending in the Rajasthan court?
Rajasthan court, the suit was filed.
That was pending.
No, not pending. Subsequently, it was filed. Probate was filed. Your lordship may kindly see again. Probate was filed on 7/10/20. Probate proceedings culminated into order on 2/3/21. During this period, a suit came to be filed. Because probate proceedings were not disclosed, only the bill was disclosed to the appellant. In a proceeding, when I was going for a patta before the municipality based on my bill of 2012 registered at Sikar by Kesri Devi Sethi in my favor. She objected. Then she sent a notice to me that you are my tenant, please pay the rent. And annexed the bill. Immediately when she annexed the bill, I took two proceedings. One, I filed the suit. Second, I filed the FIR. Those both were filed in January. On 22nd January 2021, after service on the Manju Devi Sethi, the stay order was passed. The affidavits and everything in probate proceedings have been filed subsequently on 2/3/2020 when the order was passed. She could have filing an affidavit. At least this was her duty to bring to the knowledge of the court that already an order is operating whereby the records and the status quo of the property has been ordered. How can she not bring that fact before the probate court? What was behind it to conceal? If she was clean, if his will was not fraudulent, she could have said before the court, I would have come before the Dimapur court and have contested. And after contestment, what could have been the result? That would have been different thing. Now, the lordship may kindly appreciate the duty of a court when it is taking the proceedings of probate is much more than in any other proceedings that has been upheld by the Supreme Court. Because it is a document which is declared as genuine by the probate court. What is probate? It is the declaration of a will to be genuine and the last testament of the testator. The Honorable Apex Court has said that it is a more bounden duty to see whether any suspicious circumstances exist, whether all the suspicious circumstances have been ruled out, for the reason that it is such a document that a deceased will not come to prove whether it is her last will or not. So a heavy duty has been casted upon a court, even if there is no one to contest, then also there is a heavy duty. Now kindly see the circumstances, overall circumstances in this case. 21/10/19, the will is written. I have mentioned in my...
You have mentioned in your gist.
Yes, on first page, your lordship will see the date. 21/10/19.
No.
The will is alleged to be have written in English. On 23/10/2019, it is alleged to have been registered at Dimapur. And next very day, 24, she expires. Within the next day of registration, a person is expiring. What is the mental state, physical state, health state of the lady? No one proved it.
Maybe coincidence.
Maybe coincidence. That's right. That's right. But coincidence, if it had been a coincidence, again I ask a question to myself, then they would not have absolved me from coming to this court. Before the probate court, they would have said before the probate court that look, the matter is pending between the two parties in respect to the property of the deceased. Please let him also come and then decide the matter. What prevented them? It was not a coincidence. I will also prove that from the documents. In what manner these probate? Had the court granted and seen the proceedings itself, none of the witnesses have verified the signatures of the testator. No one has said that these were the signatures of Kesri Devi Sethi from A to B, executed by her or put up by her in our presence. None of the witnesses. I'll show those witnesses also. Because your lordship is well aware, under section 67 of the Indian Evidence Act, if you are asking to put, you are saying that it's a signature of XYZ, you have to prove those signatures. Sir. And under section 69, it is mandatory provision that the will has to be proved by one of the attesting witness. Then what is the duty of an attesting witness? The primary duty of the attesting witness is to come before and say that these signatures which are there on the will are of Kesari Devi Sethi. No or none of the witness. Rather he says, my signature, the signatures of witness from C to D are mine. Your signature might be there, but you are not proving the signature of Kesari Devi Sethi. Might be a reason that you know that those are four signatures. If you say A to B are of Kesari Devi Sethi, in future you might be prosecuted. And for that reason, you did not come before the court and said that A to B are of Kesari Devi Sethi. And even your lordship may kindly see, again I will read the provision, attesting witness duty, which I was reading. Again, my lords may kindly have 281.
Yes, please.
How he has to verify? Verification is not there. Alright, but this should have been in evidence. I CD one of the witness to the last will and testament of the testator mentioned in the above petition.
You are reading 280?
281, my lords.
281, okay.
The duty of the attesting witness to verify the probate petition. I, C&D, one of the witness to the last will and testament of the testator mentioned in the above petition, declare that I was present and saw the testator affix his signature or mark there. No one has.
Let's,
After 10 minutes?
after 10 minutes.
That's very good. Very good. आज तो हम आपकी आंखों में भी नहीं देख सकते जान के।
one DP of 2019. One DP